Well, let's bring in our resident legal expert, lawyer Robert Barnes. Robert, lots to unpack this week here. First of all, let's talk about this immunity doctrine and this immunity defense that the Supreme Court gave to Donald Trump here in a limited sense. Isn't this just codifying what had already existed that the left is flipping out about?
Yes. I mean, the institution of the presidency is what they're caring about protecting, not the individual Donald Trump. And the institution of the presidency would be compromised if the individual who occupied it could be subject to extortion and blackmail threats while president, with future subsequent criminal prosecution for their policy decisions. And so they'd already immunized the president of the United States for all civil suits for damages. And all they did is extend that exact same doctrine to criminal prosecutions, and said for the exact same principles and the exact same constitutional reasons that Article 2 vests all executive power in the presidency, and that power would be compromised if the individual who occupied the presidency was continuously subject to extortion and blackmail risk by potential criminal prosecution. So all they did is extend common sense constitutional principles from the civil arena to the criminal arena.
Well, I mean, this gets to something, Robert, that we've talked about on this show before, is that people on the left side of politics, they can never sort of think about what happens when they get their way, because surely, you know, a Joe Biden or a Barack Obama or any other sort of former Democrat president would also be subject to all sorts of, you know, prosecutions by the opposition if they had their way here.
Exactly, and that opposition could be global. I mean, for example, the only thing that prevents a former president from being extradited to a foreign country for foreign prosecution is this same immunity. Without it, you know, someone unhappy with Joe Biden's policies, unhappy with Barack Obama's policies, unhappy with George W. Bush or Bill Clinton's policies, all of them could seek the extradition of someone over something that was done by the U.S. military or the U.S. government overseas. And this protects all of them, and it primarily cares about protecting the institution of the presidency. All executive power cannot be vested in the institution of the presidency if the individual who occupies it is subject to continuous extortion and blackmail risk from subsequent civil suit or criminal indictment. And that's why it protects the institution, and by so doing, protects Article 2 of the United States Constitution.
Yeah, and so let's talk about then what this means now in a practical sense for Donald Trump. I mean, obviously, he's had that whole hush money case. There's a sentencing now. That's been delayed till September. But will this case now even get thrown out? What are the chances of that? Or is this now going to be a problem where he can't appeal to the Supreme Court before the election because the timing won't be right?
Well, I think that the prediction by a few Democrats that he wouldn't be able to appeal an adverse decision is incorrect, because if the judge issues any kind of incarceration sentence of any kind, then that gives him a right of an original writ of habeas corpus right to the Supreme Court of the United States. So he would be able to circumvent the regular appellate process if the judge were to institute any kind of sentence of any kind. And so I think there is a substantial chance that this judge dismisses the case. It's what he should do constitutionally. The big question is whether this judge actually cares about the Constitution given his behavior to date. But what the Supreme Court said is that you cannot use evidence of the president's confidential communications with his own staff and team as part of any criminal case. And that's precisely what happened in the New York case. They relied on a bunch of those communications to secure the conviction. That means there has to be a mistrial, and they have to throw out the whole case and start from scratch. That's what the judge knows he has to do constitutionally. The only question is, will he honor the Constitution, or will it require a higher court to overturn it?
Yeah, and I mean, there's also more than just that particular case. We also got Special Counsel Jack Smith, who's now announced that he is going to try and pursue his cases up to 11:59 p.m. and 59 seconds the night before Inauguration Day, if Donald Trump wins, thinking that, well, he's not technically the president yet, so we can still get him. This feels like Les Miserables to me here. Is he running out of options? Is this desperation, or is this a real threat of a legal coup against democracy?
Well, I think Jack Smith would love to engage in that legal coup, and he's been engaging in it now for the better part of a year. The problem is going to be Justice Thomas's concurring opinion, and what Judge Cannon in Florida is likely to follow that opinion, which says he never had the constitutional authority to seek indictment in the first place, least of all actually go forward with it, an actual trial. So if Judge Cannon, following Justice Thomas's concurrence, says you were never constitutionally appointed, because you were never approved by the Senate as is required under Article 2 of the U.S. Constitution, then the entire case gets vacated, in at least the Florida case. And then the D.C. judge is in the position of having to decide whether to ignore the Florida judge's decision, ignore Justice Thomas's concurrence, or follow it as well. If she doesn't follow it, then that too could immediately go up to the Supreme Court of the United States before any criminal prosecution ever happens. And they've already warned the judge in D.C. that she's already made severe and serious constitutional errors in the case, and that they're going to be watching the case for her to not continue those errors. So I think ultimately both the D.C. and Florida cases will be thrown out, like the New York case, and I think the Georgia case ultimately. The only question is whether it has to go up to the Supreme Court again for that constitutional action to take place.
Mate, you're so good at sorting this out for us. Thank you. And before I let you go, I've got to ask you one last thing here. Missouri Attorney General Andrew Bailey is suing New York over Trump's gag order in the hush money trial. Tell me about this. This seems like a real sort of turnabout of the usual lawfare that we normally see. What's going on here, Robert?
So the Constitution says that if there's a dispute between the states, particularly concerning a presidential election, that you have to file that suit in the Supreme Court of the United States. So this is an original action brought before the Supreme Court of the United States. And it's because there's no question the nature of that gag order is interfering in the election. It's preventing the president of the United States, former president, and future president of the United States from communicating about an issue of great public policy and public interest, including during the debates itself, where he was not allowed to fully answer certain questions and responses from Joe Biden because of the nature of that gag order. That constitutes First Amendment violations that is, in fact, intruding and interfering in the election. So it has an above average chance. The big question is, will the Supreme Court take it up? In the past, sometimes they've dismissed those cases on standing grounds, like they did the 2020 election case. But there's a lot of people who think they made a mistake by not correcting things in advance in 2020. Maybe they'll fix it now early in 2024.
Well, we'll have to wait and see. Robert Barnes, thank you so much for your time, and happy 4th of July.